Welcome all to our Back to the Future webinar, an historical and present look at ECA, what it was supposed to be, what it was in fact, and what it should be and is today. I'm Bob Eisenberg, Director of Consulting at Empire Discovery. First, I'd like to introduce you to our esteemed panelists. We have Christopher Redlick, Litigation Support Manager at Allen Overy, Frank Cantorino, who is the Chief Technology Officer and co-founder of Empire Discovery, Joe Sherman, who is Chief Executive Officer and founder of EDT. Joe is joining us from outside Sydney, Australia. She's also an attorney and technologist. Manuel Almonte, he is eDiscovery Project Manager at Greenberg Traurig, and David Lepresi, eDiscovery and Litigation Support Manager at Phillips Lytell. We know today that law firms and corporations using traditional approaches to discovery are often still struggling to manage the enormous volumes of electronic information that can be potentially relevant. Data seems to grow exponentially no matter what restraints are proactively applied. With many office workers conceivably generating millions of documents each year, even the smallest disputes, as we know, can become unmanageable. The cost of legal review itself has escalated to an average of about 73 cents for every dollar spent on discovery. The old paper-based review every document paradigm, as we know, is a total anachronism. And clearly, in most instances, that is cost prohibitive. While judges and clients, appropriately, I think, are continuing to press for more proportionate, cost-effective approaches. Now, many law firms found new and interesting ways to address this problem. Innovative analytical technologies like predictive coding and other TAR systems are undoubtedly making an impact in terms of their potential to help legal teams to rapidly drill down and find relevant documents amidst often mountains of electronic data. Although it is arguable that the efficacy of some such systems may have been overstated, such systems may be unnecessarily esoteric, and worse yet, may tend to leave the defensive process advocate grappling with the arcane and sometimes the indefensible.
So what ECA technology allows us to do is filter out large volumes of data at the onset of a case. It really helps law firms and corporations get a sneak peek into exactly what it is they have before moving into, let's say, your linear review platform. Another key advantage, obviously, to ECA and what ECA means is it allows you to make decisions kind of on the fly. So as opposed to, let's say, keyword searching, which seems to be more of the commonplace these days, where you make a decision and you kind of live with it and then you move forward into review, ECA is quite the contrary. It allows you to make a decision, then test your decision, and ultimately see what kind of results you're getting. Go back, rerun searches, run date ranges, run all different types of searching in order to get, a handle of what you have.
I guess one thing I was going to add, Bob, is that ECA really is something that needs to be done early. I know that sounds pretty obvious, but doing ECA inside a review platform is not ECA, that's late analysis, because you've already paid for processing. So I'd just like to sort of emphasize the fact that effective ECA is something that's done early before you've incurred too many processing costs.
Well, I think what you need to think about is what actually ECA is, and it's early case assessment. So you're trying to, before you incur any costs for doc review or any type of extensive processing of the data, you want to weed out the irrelevant data set, right? So that's what you're trying to get the core data set to then send to some sort of review tool.
When it first appeared on the discovery landscape, ECA promised to deliver great economies with new workflow paradigm. If you recall those early times, I think we all thought that the holy grail of e-discovery in ECA at last had been found. However, for a range of reasons, ECA technology was not accepted as broadly as many of us anticipated at the time, and the technology never achieved its full potential, I think. I believe we can agree that we are still in search of that holy grail, although the world of ECA is improving. The flaw early on, from my perspective, maybe the most significant flaw was more from the attorney's perspective. It was a flaw in approach, as you say, not in the technology, a human flaw in conveying the best manner to leverage the new technology. There was a failure in project management, and some of that had to do with the fact that to many it seemed overly complex. But it was a failure as well in providing a comfort level both for the user and the defender of ECA's use. It was a failure in fully supporting counsel and practice support professionals to prepare to unequivocally defend the process. So the thing that I always strikes me about e-discovery, it's both an art and a science. And to some extent, the earlier incarnations of ECA and its providers ignored the all-important art that comprises much of the successful use of e-discovery and the defense of the process.
Yeah, actually, I happen to have a lot of experience with first-generation ECA, and I can tell you one of the big issues was multiple issues, but one of the big issues was the fact that it kind of operated on its own. It was its own entity and didn't really play nice with the other review platforms of the time. So, whereas you would get in there and you'd be able to mine through a lot of data, it was virtually close to impossible to get the data out effectively. So all the time and money you were saving from the ECA, you ended up losing because it just became such a challenge to get it into a linear review tool. And the other real issue with it was I don't know if the market really knew how to use the technology properly. A lot of people tend to try and use it as a review platform, some of the early ECAs, and that wasn't what they were designed for. So I think there was a great sense of frustration in that, the tool wasn't working right because, I could do this in Concordance and I can't do this in Clearwell. So I think it was an educational issue. I think people didn't really know how to use it. And then obviously towards the end, people were using, ECA, multiple ECA tools to get it out of the original tool. So those are some of the issues I think that happened in the beginning phases of it.
Was disconnected to the previous workflows that were in place that the vendors were using and the firms were using. And, although when it first came on scene, it was very exciting, but I think it was just that it was disconnected and it was hard to move it from there into the review platforms that were being used at the time.
My early experience with ECA was we had touched on this briefly earlier. Was basically the cost was a big factor. You had these tools that were supposed to help you call down and lower your data set as well as cut the costs for review. However, the per gigabyte charges on those tools was pretty high. You could range anywhere from $150 to $280 a gig. And that is completely the wrong way to go when you're trying to save money on doc review. So when we utilized EDT, the cost to conduct the investigation in ECA, or excuse me, in EDT, was a fraction of that cost, and I think that's one of the big things I've noticed from the original ECA tools. That, and as well as, be honest with you, the use of the tools and the ease of use of the tools was a big thing. We used Clearwell and tools like that, but be honest with you, the regular attorney, especially when those tools came out, the standard attorney, the associate, even a partner level, those people were not gonna dive into the tool and utilize Clearwell or a system along those lines.
I felt one of the issues with the first iteration of ECA was that people didn't really know how to use the technology right. And I think we all share in the blame, on the vendor side and on the law firm and corporation side, where we weren't really educating people as to the right way to use it. The most important thing in my business, and we do everything from end to end, is the people. It's all about the people. It's all about the people for the law firms. It's all about the people on the vendor side. So training is obviously very important. And one of the things that I happen to really like about the EDT system is it's an easy tool to train, and it's easy to get lawyers and litigation support professionals up to speed. And again, my team, and every team really needs to constantly continue to educate themselves, look at what's out there, and understand, where the market's going. But project management and support is the most important thing, far outweighs the technology.
One of the maybe the primary raison d'etre of ECA, and the way it was initially pitched, was there would be an extraordinary reduction in cost. Well, there was, but there wasn't that extraordinary reduction. We had not come to budgetary nirvana. I think, though, that may be changing, and I think some of the things we're discussing now would indicate that it could be that ECA or type of ECA is finally realizing its true cost effectiveness. Chris, you recently managed a large project that involved a very robust ECA component. Can you tell us about that experience?
Sure. We had an early phase investigation. It wasn't a standard document review project. It was basically an internal investigation for one of our clients. And we started out with about 325 gigabytes of data, which correlated to about 2.3 million documents. That data set, if we were to process that in a regular linear review, would have cost the client millions of dollars to do a standard review. So we chose to utilize the EDT analyst tool to perform an early case assessment on the data, which allowed us to bring the data in, get a quick peek at exactly what was in there, run specific searches on the data. We had two experienced lawyers that were in the firm that ran their searches on the tool. The data also contained a lot of foreign language documents that also caused a problem for us. But the ECA tool, the EDT, was fantastic. It was able to run searches on that data as well, and it provided us, with a breakdown of what exactly we were looking at, and allowed us to develop a strategy to attack the data. Once we finished our initial searching of the data, we culled it down to about 93%, which was about 150,000 documents. That's what we ended up actually reviewing in the platform, versus the standard 2.3 million documents, which we would have, if we would have done a standard review. That's what we've been looking at, and we had a pretty extensive search list that we applied to it, and it was basically a 66% call down rate off of the original data set that we cost savings that we saved the client, basically. I mean, the cost savings for us was basically when in a standard review, we provide the data to our vendor, we provide search terms, and then that data gets loaded up to some type of platform, document review platform such as Relativity or something along those lines, and that rate is very expensive, as everyone knows. It could be $200, $300, $375 a gig. At that point, when we realized that we could basically do our initial ECA in EDT and pass the data set over to the review platform within EDT, we had a huge cost savings, and we were able to cull the data set down, like as I mentioned, about 93% of the material was culled out, and we saved the clients a ton of money in that process.
The ECA worked in that case. This might be a hard question to answer, but without the ECA function, without using that tool, do you have any sense of what the filtration rate would have been rather than the 93%?
Normally, when we would have run our process, if we didn't approach it using EDT, we would have applied deduplication to the data, and we would have applied basically roughly a set of search terms to the data set, and then reviewed it that way in a linear method. It's at the most, I would say we would have culled about 60% of the data out. That's on an average. versus the 93% that we experienced using the EDT model.
We've got an audience question here from James Lawson of CCL, a very well-regarded forensic house in the UK, actually. Hi, James. James has actually got a question for Chris, and he's saying, why did your client review in relativity, not in EDT? It looks like there might be a little confusion there, Chris, about where you actually did the review.
Right. Yeah. Sorry about that. Yes, we did not use relativity. That we put together, or I put together two proposals for the team. One was an EDT approach, which consisted of loading the data into EDT and doing the review in the EDT. And the other was to export the data out once we identified the data set using EDT, exporting the reviewed set out to relativity. The cost differential was just, it was a no-brainer. The EDT model was substantially less as far as the processing fee, the processing rates, the user fees, all across the board. So we did a full approach in EDT. We did not use relativity.
Experience was really similar to Chris's. One of the benefits that we had that our lawyers had access to the data directly, and they did an enormous amount of culling before going into the review. So they had the ability to change the filters, dates, and very quickly. We didn't have to go back and forth to the vendor as we would normally traditionally would if we would had it in concordance or relativity or Clearwell. However, the biggest benefit to it was dipping into the well, so to speak. If you have the data in one location and you have the ECA tool in one area and then you have the review on the other set, as you're reviewing and something changes, which did happen on one of our matters, they can easily change the criteria of the data set in just a few minutes and easily take out from the review set, put it back into the pool, and then reassign the data set back to the reviewers. That was probably one of our biggest benefits of using the tool, and that's how we kind of used it, and it gave the power back to the attorneys. I wasn't sitting there for hours trying to figure out how to run the searches, what are they looking for. They're looking at the data themselves, and also the fact that they're looking at the actual documents, not rendered OCR versions of the documents, not TIFF or everything's like right there. So that's some of the experiences that I've been having on our end.
One of the biggest complaints that I hear from law firms and corporations is in that beginning phase, that keyword phase, because essentially what you're asking people to do is pay for something that ultimately they're going to end up discarding. And sometimes, it goes so many different ways, but we have some instances where it just comes down to budget and cost. So sometimes people don't make necessarily the best decisions. They exclude words, they change words, they refine words, just because they just have to solely get the data population down. So then, when you start cutting corners proverbially like that just to lower costs, there's always a risk. Why I think people have tended to like the offering that we have currently is that they don't have to take those chances. They can create their search terms. They can, run their data set in a normal way.
In fact, searching in general, like when you do a Google search, it is kind of an art because you may start out thinking you know the subject area and what you're looking for, but as you're starting to read the content of your results, you begin learning the actual words or the actual phrases that are used in what you're looking for. So then when you run that subsequent search, now you're really getting the rich content documents that you really started out looking for.
What is your impression of the more common view, I believe, in the industry that advocates not an integrated tool, but separate best-of-breed tools for each segment of the electronic discovery reference model, EDRM. What do you think about that?
Keep it simple is one of the underlying philosophies of the way we approach this whole solution domain. I really feel that our industry is at times guilty of complex, over-engineered solutions. The black box complexity and mystery that surrounds many practices in our industry really confuses and alienates clients and often leads to cost escalation. If I was cynical, I could say, well, where there's mystery, there's margin. I can't remember who said that. I read it somewhere, but I thought it's a great quote, because I think, unfortunately, sometimes clients have been billed inappropriately and unnecessarily for things that really shouldn't be happening. So I think that there's a massive opportunity to simplify what's going on in terms of the workflow and the way projects are managed and the way documents are processed. And, you know, it's all well and good to put together a range of sophisticated, best-of-breed, bleeding-edge technologies to support the life cycle of a case. But if they all operate as silos, and then you've got the complexity of moving data from one to the next along the whole case, of course, it's wonderful for the technologists. It's exciting and a wonderful challenge, but it really racks up the costs. You also have to start thinking about, you know, how many software licenses do you want to take on? Who's going to manage all the different hardware and software systems? How many certifications do you need? How much are you paying for the certifications? There's some pretty outrageous sort of costs for those sorts of qualifications as well. And how is the data going to be shuffled around between products? What happens if you need to circle back and change your decisions? And who's going to explain to the client what happened, or even to the court? The full audit trail of exactly what happened from the moment the data was collected all the way through to presentation in the courtroom. So I think that there's a real case for simplification through integration and you know, a creative new approach. One of the other unfortunate aspects of that model is that it doesn't reflect the real world, because in the real world, litigators don't think in a linear, structured, box to box to box, in you know, a linear sort of one-directional way. They work in a very dynamic, dare I suggest, haphazard sort of crazy world where issues change, timeframes change, new facts come to light even during the review process. And that structured linear model of moving data from one platform to the other means that you simply cannot go back and change your mind, because the decisions that you made in your processing tools are the decisions you have to live with for life, for the life of the matter, unless you want to incur dramatic costs involved in going back and changing your culling criteria or changing that early analytical decision process. So what we're trying to do is actually totally redesign the way that whole workflow works. You need to do analysis throughout the whole case. The concept of early analysis is fine, but you might want to do late analysis as well. You might want to do metadata analysis throughout the entire case. And you might want to change your culling criteria throughout the review as new issues come to light and circumstances change. So we think that the preferable approach is to actually have all of your data in one place so that every function that you need throughout the entire life cycle of the case is accessible, working off the one platform. And that is by far the most efficient way to run a case.
Let me try to shed light on the key messages of today's webinar with the help of the panel. What I think we're all saying is the linear, one-directional, but multi-siloed model that has been traditionally embraced for ECA is liable to deliver ineffective and expensive results as data is shuffled from tool to tool. I think we can agree on that. This panel can. Also, your experiences are, and my experience, that this model may not provide the flexibility that is needed. And I have to say, a flexibility that in some instances may be existential to the issues. we know in the real world issues change, time frames change, and new facts come to light during the review. We know of a fact that so much of what is unearthed about a dispute is done so throughout the discovery process. And the complexion of a matter in the early stages can change drastically by the end of the discovery process. So we need that flexibility. This all necessitates a circling back to re-examine, to re-explore the data. And that has to be done efficiently. And it may not be when you're looking at a non-integrated solution.
It gives control back to the attorney, direct control. I mean, there's nothing simpler than that an attorney being able to see his result, his or her result, immediately.
I think today we're in a much better position than we were 5 years ago or 6 years ago when, you know, the Clearwell and these early ECA tools burst onto the scene. There is options now. There is full end-to-end tools where you can utilize the ECA functionality and also use review analytics. There's new technology out there. So I think the message I'd like to convey to people is there's a better way than just creating search terms in the dark and throwing them against the wall and see what sticks. There is technology out there. We have technology that can allow you to use ECA, but again, eliminate all the headaches that the first generation had.
Yeah, I guess, Bob, I would just say that ECA without integration is probably a waste of time. ECA with integration is the new generation approach. What we're suggesting is that ECA, or some form of intelligent, informed, analytical culling, should take place before you go to a review platform or a TAR predictive coding sort of exercise. Because we must remember that there's a cost in loading data into those platforms. And we want to minimize those costs as well. So I think there's always a role for some intelligent culling and data reduction. How far you go with that will depend upon the capabilities of the attorneys, how well they know the cases, how suitable keyword and other type tools are going to be for the particular case. But we think there's a role for all of these technologies, and it's just a matter of picking the right one for the case. But I would suggest that ECA is something that's needed in every case.